Copyrights and patents define rights to intellectual property. Copyrights protect creative works, and patents protect inventions such as software. Copyrights are not forever. They last for a limited amount of time, and it usually ranges from the life of the author plus 70 years. However, it can be extended. But after that period is over, the work goes to the public domain where anyone may freely copy and use it to their discretion. When you are a copyright holder, you have the right to make copies, to produce derivative works, to distribute the copies, to perform the work in public, and to display the work in public. High-speed internet allows for downloading high-quality copies of music and the ability to stream high-quality videos. This proves as a problem because since you are no longer needed to purchase the content, you can easily share the content to all of your friends without them having to repurchase it. Distributing works the same way. Since we can easily compress high-quality files and send them to our friends, they no longer have to purchase it. We only have to do it one time. The fair use doctrine is a law that does not require the consent of the copyright user due to the fact that when another person uses a copyrighted material to create a new work, it most likely will not deprive the original author for their income.
Some responses to copyright infringement include software industry creations, banning, suing, taxing digital rights. With software industry creations includes hardware dongles, anti-copying, software policies, and law enforcement raids. For banning, suing, and taxing include Walt Disney and other companies that were started suing to enforce copyright. And then digital rights management, or DRM, included embedding features to stop stealing. The DMCA. This law has two significant parts: the anti-circumvention provisions, which restrict circumventing copy prevention systems, and safe harbor provisions, which protect websites from copyright infringement lawsuits by users of the site. Anti-circumvention provision prohibits circumventing technological access controls and copy prevention systems implemented by copyright owners and intellectual property. Some exemption from the DMCA. This allows the Library of Congress allowed some circumvention for fair use purposes, such as research on security vulnerabilities for CDs, but not for video games, and to allow text-to-speech software. Safe harbor provision protects websites from lawsuits and criminal charges for copyright infringement when users post infringement materials. Safe harbor on the cloud currently is allowed to store copyrighted information on the cloud, but there's talk whether the cloud should check for that sort of information and if it would restrict fair use.
Search engines display copies of text excerpts from websites. They also display copies from images and videos. They also copy and cache web pages to respond quickly to user queries. They provide links to sites that may contain copyright infringing material, but most importantly, search engines are a valuable tool for making information easily available. Kelly vs. Ariba software. It's a case that revolved around copyright infringement pertaining to creating and displaying thumbnail images from other web pages in search engines. The court ruled that creating and displaying thumbnail images is protected under fair use. Field vs. Google was another case where an author sued Google for copying and caching a story he had written and posted on his own website. The court ruled that caching web pages fits under the fair use guidelines. Another case similar to Field vs. Google ruled that caching and displaying small excerpts from other web pages fits under the fair use guideline. Belgian newspapers and Google. A group of Belgian newspapers sued Google for displaying headlines, excerpts, and photos from their news archives, claiming it was causing them to lose money from their subscription fees. The Belgian court ruled in favor of the Belgian newspapers in 2007. Similar disputes have caused Google to negotiate licensing agreements when copying and displaying things such as headlines and excerpts. Intellectual property issues have arisen for trademarks pertaining to the practice of selling search terms. Some businesses will pay search engine companies such as Google to display their business ads when users search a specific term. In 2009, the case Rosetta Stone Ltd. vs. Google Incorporated was filed, which pertained to trademarking search terms. The case is still ongoing in the courts. Project Gutenberg started converting books from the public domain to digital formats in the 1970s. In an agreement with the University of California, Microsoft scanned millions of books in the university's collection that were also in the public domain. Google provides entire books for download, but only if they are in the public domain. For books still under copyright protection, Google Book Search only provides excerpts from the books. Many lawsuits have been filed against Google by publishers and authors for copying their books. Many of these lawsuits have been settled in agreements between Google and the publishers.
I'm going to talk about free software in section 4.1. Free software means software that respects user freedom and community. Roughly, it means that the user has the freedom to run, copy, study, change, and improve the software. Its source code is open and available for anyone. To understand the concept, you should think free as a free speech, not as a free beer. On the other hand, we have a commercial software, which is an opposite of free software. It means that you have to pay when you use the software and it doesn't have the open source code. This is another section of 4.4 about Richard Stallman. He is the best known founder and advocate of the free software movement. He began with the GNU project in the 1970s and is also begun with a Unix line operating system and sophisticated text editor and many compilers. GNU now has 100 of programs freely available and popular among computer professionals and skilled programmers. In addition, there are thousands of software packages are available as a free software, including audio and video manipulations packages, games, educational software, and various science and business applications. So what is an advantage of using free software? A good thing about using a free software is it's free, so many people or programmers can use it and benefit from it without any restriction. And most of the free software has an open source code, so many programmers can copy, modify, and improve it freely, or create a better one based on the original source codes. But since it's a free software, most of them only have a basic functions and often have a friendly user interface. And it may contain a virus too. This is the last section of 4.4. So should all the software be free? Some people in the free software movement, they don't believe in the software should be protected by the copyright and the government. And it should always have an open source code. However, how can the developers get paid when they donate their work? Usually they don't. They don't expect anything in return but helping others people. Some of them do get paid from user donations. Richard Stallman says there are many programmers are willing to work like an artist for the low pay. He also pointed out that the primary purpose of the copyright, as stated in the U.S. Constitution, is to promote process in art and science, not to compensate a writer.
Companies buy patents not because they actually need them for active products they are developing, but so they can sue companies for patent infringement, after those same companies sue them for patent infringement. Software companies pay billions of dollars in smartphone patents alone just to be used in these courtroom wars. Patents protect creations by allowing the owner of the patent a monopoly for a specified amount of time. The current time is 20 years. Patents protect the invention itself, rather than a specified implementation like copyright does. Anyone wanting to use the patent invention will need explicit permission from the patent owner. In regards to software, patents are a relatively new thing. In 1968, the Supreme Court declared software unpatentable. In 1981, the Supreme Court said software could be included in patents if a machine uses it and the sole new aspect is software. Patents now cover a wide variety of software aspects due to the loose applications of the Supreme Court ruling. Among these are algorithms, e-commerce techniques, and smartphone features like email and location services. Microsoft co-founder Paul Allen sued a ton of companies like Facebook, Google, Netflix, and many more for violating a few early patents relating to e-commerce and viewing the internet features. Apple won a case against a creator of Android phones because they hold a patent that covers devices that allow a user to tap a touchscreen to perform tasks. Some companies, while not developing products of their own, buy many patents just for the sole purpose of charging larger companies licensing fees to create products covered by the patent. Some view this as a flaw in the system, while others view the practice as reasonable as long as the patent itself is legitimate. The in favor argument has these points to say. Patents for software-based inventions reward inventors for their work, and that encourages other inventors to build upon it. In the days of the original Supreme Court ruling, most innovations were due to physical devices, but in this day, many innovations are software-related. Copyright on its own is not sufficient for a lot of software. Businesses already pay royalties and fees for uses of other IPs, and software fits nicely into this mold. As for the crowd that's against it, critics see patents as holding back innovation as opposed to encouraging it. Software is such a broad field that it would be hard to tell if one software would infringe on a patent or not. Prices will rise on software if courts uphold patents for software techniques due to court and licensing fees. It's difficult to determine what's original and what is patentable innovation.